right, let's proceed.
Good morning. May it please the Court, my name is Ann Rusev, and I represent Michael Ray, the defendant. I'm asking this Court to order the dismissal of these indictments because there was no manifest necessity for the mistrial in this case, and therefore to subject my client, the defendant, to a second prosecution would violate his right to be free from double jeopardy. It's the Commonwealth's burden to demonstrate a manifest necessity. It is a heavy burden, which is acknowledged in Arizona v. Washington and Commonwealth v. Cruz. And in this case, it's a burden that the Commonwealth cannot carry because the judge did nothing to verify that there was a deadlock before abruptly aborting the proceedings over the defendant's objection. In this case, the standard is abuse of discretion. However, the Stewart case and the Jones case indicate that a trial judge's discretion in this area is restricted because the right to be free from double jeopardy is a fundamental constitutional right.
When you say the judge didn't do anything to ascertain if there was a deadlock, the jury sent him a note saying we were hopelessly deadlocked. Can't the judge rely on that statement?
Not entirely. It's up to the judge to determine when there's a deadlock, not the jury, and that's because the defendant's right to be free from double jeopardy is so important.
So what should he have done?
The judge, well, the counsel's request was for the Chuy Rodriguez instruction. That would have been the most obvious choice, one that's commonly done in the Commonwealth. Another choice would be to inquire of the jurors themselves. That's something that happened in the Thames case, in the juvenile case, in the Barbioni case, which is a First Circuit case recently cited by this court, to do something to make sure that this actually was a unanimous position of the jury, that there was no further deliberations that could be useful, no further instructions that could be useful. And I would point out the Commonwealth argues that there's no case in this Commonwealth holding that a judge's determination of a deadlock was an abuse of discretion. That's correct. However, there's also no case affirming a judge's determination of deadlock based on so little evidence. In this case, we have one note.
But I mean, don't we have to look at the larger circumstances? That is, it's a very short case, and the judge was there. I mean, I don't know what the evidence was, but as I say, it is a very short case. You've got this note. I don't think that as much as we say Chuy Rodriguez should be given, it isn't a sine qua non for a valid conviction or hung jury. So I guess I'm just wondering why we don't have to accord the judge, in applying an abuse of discretion standard, we don't have to accord the judge a fair amount of leeway in making that judgment on the ground in the circumstances in which he found himself.
Well, I think in that way, this case is similar to the Barton case, where the judge didn't collect the information necessary to exercise his discretion. In that case, there was a juror who was afraid of one of the co-defendants. The judge excused that juror and another juror that she had spoken with, but then didn't do an inquiry into the remaining jurors to determine if they had been tainted in any way. Didn't give due consideration to the possibility of severance before declaring a mistrial over the defendant's objection. And in this case, similarly, the judge just didn't have enough information. This one note wasn't enough information to go on, and to fail to collect the information necessary for an informed exercise of discretion is in itself an abuse of discretion. The information could have been gathered by giving the Chuy Rodriguez charge. It could have been gathered by doing an inquiry of the jurors themselves, as happened in other cases, but that just didn't happen here. And there is no case holding that even without the Chuy Rodriguez instruction, even without any inquiry into the jury, that the judge had sufficient information to declare a deadlock. In the other cases where Chuy Rodriguez was not given, there was additional information. There were multiple notes. For instance, in the Thames case. In that case also, during an inquiry of the foreperson kind of blurted out that they were actually disposed 11-1 in favor of conviction. So in that case, also Chuy Rodriguez was not, surprisingly, requested in that case after learning that disposition. So in that case, the judge had enough information. In the juvenile case, there was only one note passed, but the jurors did affirm in court that they were deadlocked. Additionally, what's interesting about the juvenile case, and unfortunately I didn't quite explicate this in my brief, in the juvenile case there were two indictments. There was a murder indictment and there was a firearm indictment. The jurors actually came to a unanimous verdict as to the firearm indictment, and they reported that they were deadlocked as to the murder indictment. So that judge had additional information aside from just the note. That judge knew that this was a group of people who were ready, willing, and able to deliberate, and they had actually successfully deliberated onto one indictment. So in that case, I think it's fair that the judge could give some additional weight to that note that they were deadlocked as to the murder indictment, because there wasn't a failure to deliberate, period. They had successfully deliberated on the other charge.
So, I mean, in essence, the rule that you're asking us to adopt is that where there is only one deadlock note, a judge must give a Tui Rodriguez charge.
I'm not asking the court to adopt that rule. I think that the prior cases instruct that the judge must do something to verify the deadlock, and this case falls right in line with that. So I'm just asking the court to be consistent.
Then your rule is that if the judge does not give a Tui Rodriguez, he has to make an inquiry of the jury to make sure that they are deadlocked?
I think that would be advisable to make sure that there is actually a unanimous position in the jury, that there's no further deliberation, no further instructions.
And if that were to happen, do we have to worry that CPCS would come back after a guilty verdict to say that that inquiry constituted undue pressure on the jury to have that kind of a colloquy with a deliberating jury? I would worry about doing that as a trial judge.
Well, I think that there are cases where an inquiry has been upheld as proper, for instance, in Thames and Juvenile, and the First Circuit case, Barbioni. I don't think that the court has to go so far as to create a prospective rule requiring inquiry or requiring the Tui Rodriguez instruction. All that has to happen in this case is the Commonwealth has to prove that there was a manifest necessity for the mistrial. And in order to do that, the judge must have had sufficient information. It's possible that in a different case, maybe one note had sufficient information. Maybe the judge made observations of the jury that supported that. Maybe the judge would have made factual findings that would support that determination. But in this case, it's lacking.
But I mean, the problem, of course, is that a trial judge doesn't know anything more about what goes on in the jury room than anybody else, nor should the judge know what's going on in the jury room. So where is this information going to come from, apart from what's obvious to all, which is the length of the case, the difficulty of the case, and what the jury writes in their note?
Certainly, and in this case, there is only one note indicating there was a difficulty with deliberation. The previous notes were just questions about the law as it should apply to this case. So it's possible in another case there would be other hints in the communications from the jury that there were difficulty, that perhaps there was a holdout, perhaps there was someone who wasn't deliberating. But in this case, we just don't have that information.
So
we have.
No, go ahead, finish.
All we have is one note, and that one note at the first indication of problem, the judge abruptly terminated the trial without giving due consideration to the instruction and terminated the trial over the defendant's objection.
But can we infer that all, I think there were 12 jurors here that were deliberating, can we infer that all of them agreed that that note expressed their collective view that they were hopelessly deadlocked?
I think that the better course would have been to do an inquiry, because if the whole question is a failure of unanimity, then perhaps you can't just accept the foreperson's word.
So what would the inquiry look like here?
Well, in the Barbioni case, for instance, the jurors were brought into the court one by one, and they were asked, is there any further deliberation that could be useful? Are there any further instructions that could be useful?
And if one person...
They were brought in one by one?
In the Barbioni case, they were individually polled. That's
and
correct.
if one juror says yes, it would be useful, and 11 say no, what's the result?
Well, I think in that case, perhaps further instruction would be useful. It depends on how far down the line you are. If Tui Rodriguez or in the federal system, the Allen charge were already given, and you were still at that position, then perhaps it's an appropriate time to declare a deadlock. But in this case, we just don't have that information.
A U.S. versus Barboni's federal case.
That's correct. It's a First Circuit case.
Yeah. So that was done in accord with some federal procedure that permitted that? Or it was just judge on his or her own deciding he'd like to make individual inquiry of each juror about whether they were really, really deadlocked?
I'm not 100% sure. I believe that it was on the judge's own, but I would have to double check to be totally candid.
Okay. Now, the judge found that there was that giving a Tui Rodriguez charge would entail a serious risk of jury coercion. Is there any factual basis for that, apart from the note?
it's my position that there is no factual basis for that. The judge did not make any factual findings to support that conclusion. He just said, based on, I believe his wording was, based on the communications from the jury and in light of all the circumstances, he felt that it would entail a serious risk of coercion, but did not make any factual findings to support that. So it's our position that that is a determination that is not supported by the record.
What were the, I should know this, but what was the nature of the earlier questions?
There are actually 4 questions. The first question was about whether the jury could consider the fact that the main witness, a police officer, did not follow the procedures in the Boston Police Department rules and procedures about seized money. In response to that, the judge gave a instruction that pretty closely tracked the Bowdoin instruction. The second note contained 3 questions. One of them was, what is the legal definition of seized money? One was about whether evidence of negotiation was sufficient to establish deriving support even if money did not change hands. And the third, I would have to double check.
Oh, that's okay. But it's sort of specific to the evidence in the case.
That's correct, and gave no hint as to any difficulty in deliberation if any juror was refusing to deliberate or anything like that. It also gave no indication of how the jury was broken down, if they had established positions in favor of acquittal or conviction. Your Honor, the Commonwealth has a heavy burden to demonstrate a manifest necessity. The cases are clear that the court should only defer to the judge's determination if it's clear from the record that the judge gave counsel a full opportunity to be heard and also gave due consideration to all of the available alternatives. In this case, the judge, in a preemptory fashion, announced that he was not inclined to give further instruction after hearing the first report of deadlock. Did hear from counsel, heard their suggestions, but did not change his course in any way, so I would argue that that's not actually a full opportunity to be heard. Additionally, the court did not give due consideration to other possibilities, such as the Tui Rodriguez instruction, or did the judge fail to take any steps, really, to verify?
Well, you say he didn't do it. That doesn't mean he didn't give due consideration to it. He actually says he did give consideration to giving the Tui Rodriguez charge and felt it was inappropriate. And with respect to heavy burden, while there are so many instances and different types of circumstances in which mistrials may be allowed, but the most common one is simply a deadlocked jury. How much of a burden does the Commonwealth carry when the jury comes in and says we're hopelessly deadlocked? What's the burden? That's it.
Well, as I said, it's the judge's determination that matters. The judge has to determine that the jury is deadlocked. Certainly, jurors come in all the time and say they're deadlocked, and then after getting more instruction, often come back with a verdict. So it's not up to the jury to make this determination. It's up to the judge. And because the defendant's right to be free from double jeopardy is so important, because he has this very strong constitutionally protected interest in resolving this confrontation with society through a single proceeding, the judge has to weigh other alternatives.
So you're saying the judge abused his discretion, really?
That is what I'm saying. By not collecting enough information for an informed exercise of discretion, whether through further instructions, whether through polling the jury, the judge failing to collect that information was an abuse of discretion because he couldn't make an informed decision without additional information. And I would just point out, just briefly, the Commonwealth does rely on the Fuentes case. There's 2 main differences between our case and that case. One is the jury there actually sent 2 notes indicating they were deadlocked. After the first note, the judge actually did give the Tui Rodriguez instruction, and then after the second note, declared the deadlock. So I think that our case is very different from that case and different from all the cases the Commonwealth cites because the judge here had the least amount of information. So for those reasons, I believe the judge did abuse his discretion in abruptly declaring the mistrial, terminating the trial over the defendant's objection, and for that reason, a retrial would violate his right to be free from double jeopardy. So I would ask the court to dismiss the indictments.
Thank you.
Thank you very much.
Good morning, Your Honors. Paul Lynn for the Commonwealth. May it please the Court. Both the Supreme Court of the United States and this Court have repeatedly referred to a hung jury as the prototypical or classic example of a manifest necessity for a mistrial. And this case is no different.
Do you think that's I don't think that's the dispute. The question is whether this was indeed a hung jury.
Yes. And I would again cite the language in Fuentes with acknowledging the distinctions that my sister made. But as in Fuentes, the language here was completely unequivocal. The jury says, we have carefully considered the evidence, and we are hopelessly deadlocked.
Okay, but the ADA wanted a Tui
Yeah,
Rodriguez
both
instruction.
both parties recommended a Tui Rodriguez instruction, and the judge, I don't think there has to be a factual basis for it. The case law is clear that the Tui Rodriguez charge has been called the dynamite charge for a reason. It is a potentially coercive charge, even with the alterations that were made to it through Rodriguez. So the judge,
But the ADA obviously thought it was appropriate and lawful to give it.
yes, he certainly did.
So is it your position that he was wrong, that it was not appropriate and lawful to give it?
It was something that the judge could consider and did consider, and the judge said, no, in my discretion, I don't think this is a situation where it's warranted. The jury has come back. They've deliberated for this amount of time in a very short case. They've been responsive. They've asked questions. They're obviously conscientious. And now here they come back with this note that says, we've considered everything, and we are hopelessly deadlocked. So just as the jury doesn't decide, as my sister said, the jury doesn't necessarily decide whether the jury is hopelessly deadlocked, neither does the prosecutor.
But you don't get a Tui Rodriguez charge unless the jury says it's deadlocked.
Correct.
So how is the judge supposed to know? I mean, a jury will often say we're hopelessly deadlocked, and then you give a Tui Rodriguez charge, and they come back with a verdict. It's happened, I'm sure, to every trial judge. So how is the judge supposed to know that this jury really means it?
For the factors that are based on the facts that this court has already discussed, the length of the trial.
How could you just go through those? Was it one day?
It was a one-day trial. If I remember correctly, we've agreed with the facts in the
So it was
counsel's
on a
affidavit.
Friday,
So
and did they start deliberating that day and then continue on the Monday, the following Monday, or?
I believe the Commonwealth started presenting evidence about 2:30 in the afternoon on the first day. The case was sent to the jury about 3 o'clock on the next day, so it's almost exactly one business day.
Okay, and this was that day? This was happening that day or the third day?
The third day. They come back the next day.
So they deliberated a bit on the second day, came back the next day, and then this happened at what time?
2 o'clock.
2 o'clock, thank you, yes.
So they
again,
started at 9:30, I think the record said?
correct, and of course there was time taken up by the addressing of the questions. But the judge here heard the evidence, was present when he responded to the questions that the jury asked. It is a short trial. Justice Cordy?
No, I mean, I suppose you would agree that the judge could have given a Tui Rodriguez charge. There would be nothing inappropriate or unusual about that.
No, it would have been an appropriate exercise of his discretion to give the Tui Rodriguez charge.
So the question, I guess, that we have to answer is whether we are really going to require something in every case in which the jury says they're hopelessly deadlocked. Are we going to require some further gathering of information or some further actions by the judge?
Correct. And I'd say in this case that would be...
Not as a matter of discretion, but as a matter of law.
As a matter of law. And that would be unprecedented in Massachusetts. And indeed, I could not find a case in which any court has ever declared that a note from the jury that they were hung was not a manifest necessity for mistrial. I can't say I did a thorough search of all 50 states and the federal circuits, but certainly none of the cases the defendant cites and none of the cases I found while looking at those cases.
So if this case had been a 2-week murder trial and the jury had deliberated for 1 day and came back saying we were hopelessly deadlocked, it might be an entirely different question.
Yes, that would be a question where you could say, yes, the judge in that situation abused his discretion because nobody, even under the broadest definition of abuse of discretion, that you could make an argument that no reasonable judge could have concluded that the jury had considered the evidence thoroughly in that situation. And there's a lot of good language in this on the cases where the giving of the Tui Rodriguez instruction was challenged as to the circumstances into which that instruction should be given. But I would point out there are plenty of cases in which the court has cautioned against the dangers of giving a Tui Rodriguez instruction, and of course, more generally, the danger of influencing the jury. Again, it would not have been an abuse of discretion, as happened in a Juvenile versus the Commonwealth, for the judge simply to bring in the jury and say, are you in fact deadlocked? And they all nodded, or if somebody shook their head, then that would be something entirely different. But it was not an abuse of his discretion simply to take this extremely clearly worded note that said not only that they were hopelessly deadlocked, but they were hopelessly deadlocked after carefully considering all of the evidence.
So would it have been appropriate for the judge to have polled the jury in this case?
I would not go that far and say I'm like this court, concerned about the idea of polling the jurors as to whether or not they were hopelessly deadlocked. I think that raises a serious specter of coercion, even more so than Tui Rodriguez instruction.
For the sake of argument, if there had been a polling of the jury, and one juror said, gee, I think, talking about this a little bit longer would be really beneficial, and the other 11 sort of stared at this person, what do we do in a case like that?
Again, I think that's why we give the judge discretion to say that would be certainly the situation where the judge can conclude, well, this is obviously the juror that the rest of the jury is concerned with, and here we have a situation in which it looks like an 11-to-1 split, and that would be a situation in which further deliberations and the giving of a Tui Rodriguez instruction might be especially coercive. And again, if the judge had done that here, and the jury had come back with a guilty verdict, we would probably be here on the grounds that the judge had coerced the jury. So what the Commonwealth is asking for is a continuation of the unbroken practice that when the jury says, we are hopelessly deadlocked, the judge can take them for the word, to respect the jury enough to say they know best what's going on in the jury room. In fact, they're the only people who know what's going on in the jury room, and I should respect that.
Yeah, but it's not disrespectful to give a Tui Rodriguez charge.
No.
So how is it? And a judge doesn't know anything about what's going on in the room. The judge takes the note the way any of us do. So I don't know. I don't get the respect issue. The respect issue suggests that it's disrespectful for him to have given a Tui Rodriguez charge, but you asked for one.
Yes, we did ask for one. We're not disputing that. It would have been entirely proper for the judge to give it. It was also entirely proper for the judge not to give it. That's what discretion means. The question is, was this such an abuse of discretion that the defendant is entitled to a dismissal of the charge? And the Commonwealth's argument is that would be both unprecedented and bad policy. So for those reasons, the Commonwealth would argue that the judgment below should be affirmed and that the defendant should be eligible for retrial. Are there any further questions?
Thank you, Counsel.
Thank you very much.